Welcome back and welcome to Business and Immigration Law Updates. This is proudly presented here by Attorney Ramesh Khurana, who is the Chief Attorney and Counselor at Law at the Khurana Law Firm located in the heart of Gaithersburg, Maryland. The moderator here on this set is Attorney Kenneth Haber. On this early Saturday morning, Attorney Haber questions Attorney Khurana on J-1 exchange visitor subject to restrictions and waivers. Very interesting. Let's take a close look.
Welcome. My name's Kenneth Haber. I'm a former Assistant United States Attorney and a former Senior Attorney of the Office of Inspector General of the United States Department of Health and Human Services, the Medicare cops. Today I'm in the studio with Ramesh Khurana. Ramesh is an internationally known immigration attorney who has a practice that literally spreads across the world because of the fact he deals with immigration issues for people from across the world. And this is the Capital Forum. Welcome, Ramesh.
Thank you. You have made my day. Very generous introduction.
Well, it's just all true.
Especially coming from your mouth.
Well, thank you.
Thank you.
Are you ready for the first question?
Yes, I am.
Okay, let's move on. So I don't think of funny thoughts. What's the purpose of the J-1 student exchange visitor program?
The exchange visitor program really fosters global understanding through educational and cultural exchanges.
Is that sort of like our globalization of the world?
Believe me, that was the real purpose of J-1 program. All exchange visitors, because J-1 visa holders, they are called exchange visitors. They are expected to return their home country after the completion of their program. They are not supposed to be staying here. And for most of the programs, they are required to go back to their home country and stay there for 2 years. Now, this kind of condition is very strictly enforced unless you can ask for the waiver under 5 conditions. So, my dear friend, when we are talking about spending 2 years in your home country, let's say that a person has come from India on J-1 visa and he goes back to India for 1 year and second year he spends in London or in Canada. So, after 2 years, if he wants to come to the United States, let us say on H-1B visa, he is still not eligible. The reason is he spent just 1 year in India and the second year he spent was in London or Canada. So, he has to spend 2 years in his home country in order to be eligible to get any kind of other immigration benefit, like whether maybe non-immigrant or immigrant.
Is there any reason for that other than the fact that it's the law? Is there some reason behind that law?
Because, when people come here, as I said, it fosters better understanding among the people. Like people are coming, they have certain skill sets of their respective countries. And those countries want these kinds of countries back. They want to use their knowledge and experience for the benefit of their own countries. And there are certain countries which really have refused to grant waiver based on no objection. Like, India is one country which would agree to give a no objection to a person who has stayed here and he wants to seek a waiver. They will probably issue a no objection. Of course, there are certain guidelines, but there are certain countries in the world who say, no way, we cannot give no objection. Because again, it's a kind of brain drain from that country.
Right, and India has a very highly educated middle class, and
they can afford to lose
some of the brain.
That's right.
But other countries where they're just developing their middle class educated cadre, they can't afford to lose them.
No, but there are different other grounds, maybe ground fear of persecution, like a person has come from Balochistan in Pakistan and there is really a fear of persecution. Based on that, he can apply for the waiver. So, there are some other grounds, but as regard no objection waiver is concerned, it depends upon the policy of the particular home country.
What's the J-1 visa waiver?
Yeah, it basically is waiver is sought in order to bypass the to your home country physical presence requirement. As I said, the person who has come here on J-1 visa, after the completion of the program, that person has to go back for 2 years in his home country. You know, the funny thing I have seen is sometimes people take very short duration assignments here in the United States. Let's say there is a computer software engineer and he gets some opportunity to fix some program in the university for 4 weeks and he comes on J-1 visa and unfortunately he is stuck because he came here on J-1 visa unless he can fall in one of the exceptions and the waiver is granted even for 4 weeks. So, people have to be very, very careful you know, when they are seeking to come here on J-1 visa.
Would there have been a more appropriate visa for him to come if he wanted to come for just a short period to do a specific short-term job?
You know, again, let us say we are talking about the computer engineers. There are sometimes B1, B2 in lieu of H1B. There are certain conditions which are prerequisites which are to be met with. Let us say a person is on B1 and he has got his company's project here and he just wants to come and fix some particular glitches in that particular software. He may be allowed for 3 weeks, 4 weeks, which is called H1B in lieu of B1, B2. But nowadays embassies have become very tough to grant even H1B in lieu of B1, B2. Yeah.
It seems like they think that they're protecting something that needs to be protected when actually we need the people here to fix something.
I know, but they are just following the immigration laws which are passed by Congress, because if law doesn't permit it, though it makes some common sense, they have their hands tight, you know, they can't do it.
What's the easiest way to waive the 2-year home country requirement?
We were talking about the no objection statement from the country or no objection letter. I would say, rather some people say that's the simplest way to do it. Other options would include waivers based on exceptional hardship and fear of persecution, and there are basically 5 bases on which you can apply for a waiver, and they, of course, the no objection is one of the very popular waivers based on which you can apply. And I have seen, as I was mentioning earlier, people who come J-1 visas and especially they are Indian nationals, there is a system of applying for no waivers following the system, which is very well explained on the website of Indian Embassy in USA. There are certain steps which they have to take. First of all, they have to complete the application prescribed form which is by the embassy, and they have to sign certain affidavits. So, they are disclosing to the Indian Embassy in the United States like why there is a reason that the no objection statement should be granted by India. So, they have to file those papers and affidavits to 3 places in India. One is the state government from which this person comes from, and second is the central government like Human Resources Department, and third is the regional passport office. This regional passport office is the office which issued the passport to the applicant. So, this is called NORI, no objection returned to India. So, this NORI letter will be issued when all the 3 federal or central government and state government and the regional passport office, they have issued no objection letters. These will come and these will be submitted to the Indian consulate wherever the person is living. Let us say a person is in Chicago, so he will fall under the jurisdiction of Indian consulate in Chicago. So, he will go to the admission office and give the papers, and when all these papers have been submitted, the Chicago office will submit the necessary paperwork to the US Embassy in Washington DC, and Washington DC office of the Indian Embassy will submit the no objection statement or letter to the State Department.
Takes a lot of going about.
It takes a lot of time, but the good news is at least India agrees to give the no statement letter. As I said, some of the countries just don't have the policies to issue the no objections, and if you are not married to a US citizen, you cannot ask for the waiver based on extreme hardship to your spouse, or you don't meet with the other criteria, you are stuck. Then you have to go back to your home country and spend 2 years. So India is at least very generous to give the no objection letter.
Yes.
Yeah.
Yes. But they probably, like we said, they have a lot of people who are highly trained, so it, means less mouths to feed there and more money coming back to them when people are sending money home to their families.
I agree with you. Yeah.
What are some of the common reasons for denial of the J-1 visa waiver?
It all depends. There is one document which is called the statement of reason. When you go online and create your case history and saying that I want to apply for the J-1 visa, you get the barcode information, and this barcode information has to be supplied to the Indian Embassy also, because by using that barcode you will submit the necessary information to the waiver division of the US State Department. Sometimes when they read the statement of reason that why this waiver has to be granted to this person, State Department is just not satisfied. They say, sorry, you do not meet the requirement because reasons which are offered, they do not outweigh the program or foreign policy considerations. There is a foreign policy consideration when you sign the exchange agreements. So now the question can you file an appeal? No, unfortunately you cannot file an appeal against the decision of the State Department. Only you can file the motion to reopen or reconsider if you have got some new evidence which you are unable to submit first time, and now you have an evidence, you can file a motion, otherwise you lose that opportunity.
What options does a J visa holder have if a waiver application is ever denied?
Of course, in this kind of situation, this person is in great trouble, because waiver application has been denied and this person now is left with no other options. But if that person qualifies for any other type of waivers, let us say in the meantime he was single and he gets married to a US citizen, and if his departure from the country is going to cause extreme hardship to the US citizen.
Could be a benefit. It could be a benefit if they don't get along.
Right. So based on the extreme hardship to the US citizen spouse, they can file for the waiver, or based on fear of persecution, which I developed now. So then if no such reason is available, then this person has to go back to his or her home country and spend 2 years before that person can come to the United States on any kind of other visa.
Can I begin the process of filing of an H-1B without obtaining the waiver of a J-1?
Very good question, Ken. Yes, you can apply for H-1B visa without obtaining the J-1 waiver, but people have to remember that you will get an RFE when you disclose in your petition that you are on J-1 status. Now USCIS likes to see that you have sought a waiver and it has been approved by the State Department. Oh, by the way, when this waiver is approved by the State Department, they send the waiver approval direct to USCIS as well. So they will connect with that record. And if in the meantime, because nowadays H-1B petitions are filed on April 1, because the requirement for H-1B is more than the numbers available, and in the meantime if that person has applied for the waiver based on no objection statement from the country, so waiver is still awaited. So in the meantime, maybe when the RFE is issued, they ask for more evidence. Hopefully at this point of time you received the waiver application, And once the waiver application is approved, you can send it along with the RFE, then you overcome this problem.
Very good.
Yeah, so you can really start, yes.
But what you really need is a good attorney coaching you all the way through it.
That's very, very important. It's very cumbersome and tedious process.
Yes.
Very
yes.
cumbersome, yes.
Well, it's about time that we wrap up. Is there any last word, thought that you'd like to express to our viewing audience before we wrap?
You know, I would simply like to say that no objection statement is an official diplomatic communication to the United States Department of State from a J visa holder's home country, which states that the home country does not object to the J visa holder remaining in the United States and returning for 2 years. So that diplomatic communication is the core in regard to obtaining a waiver based on the no objection statement of the country. It's very challenging, very hard to obtain it. But now, let's say for example, a person come from India, they have put it on a portal as from February of 2016. So that's a good news.
Very good. Well, thank you very much for coming on in and sharing all this information
Thank
with
you.
us.
It has been my pleasure spending time with you.
It's our pleasure. Thank you.
Thank you.